Hi, this is Ken Crotty, and I want to say thank you for taking half an hour on your lunch break, Thursday, July 9th, to go over LLCs with me. What more can you ask for out of a day? I know it sounds really exciting. With the restrictions from COVID still in place, certain things you can't do, but here's one exciting thing we can do together. So hopefully it won't be too boring, and hopefully you'll find a couple of things that are worthwhile and useful for your time, useful for your practice, and will help you, in your representation of your clients. Or if you are a client, help you have a better understanding of the use of LLCs, what's important with respect to the LLCs, making sure that you have a better understanding so that the LLCs as part of your planning can be maintained correctly and the entity can be respected accordingly. A couple more webinars that we have coming up. I'm not going to go through them in detail. You can read through them. We've got a couple of free ones. We also have some other slides which we'll be attaching showing the other upcoming webinars. What I did want to do before we dive into the LLCs is show the slide that we have here, which shows a traditional planning for a married couple. We use this in a lot of our webinars, so you might have seen it before, but it shows the spouse with a revocable trust, gifting trust, a spousal lifetime access trust, and tenants by the entirety's assets. When we turn to part 2, you will see what is relevant for our discussion. And here, the FLPs, where we see those are family limited partnerships. It works the same way for a family limited liability company. So just a regular LLC could be in place for those FLPs. It would help to provide creditor protection, help to provide firewall protection, and can also provide control at the LLC level by being a manager, which would not be possible at the trust level if the grantor was the trustee and cause inclusion in the estate of the grantor for estate tax purposes. So this is just a quick overview. What we're going to do, I have another overview again showing a similar setup for a single person. This is from our estate planning for the single individual and webinar we gave earlier. So if you'd like a copy of that, let us know. We'll be happy to send it to you. And again, just showing the use of LLCs. Again, FLPs and LLCs are interchangeable. Showing the use of LLCs in planning and how they can be used to better protect the assets of the individual. So going through, what I thought we'd do is talk about LLCs in general for a little while, talk about some of the tricks, strategies, some of the things you need to make sure are in your documentation to help provide better creditor protection and to also help maximize the planning for your clients or for yourself. So the first thing, and it seems kind of obvious, is an LLC should have an operating agreement. The operating agreement defines the relationship between the members. If there is no written operating agreement, Florida law by statute provides default provisions with respect to the governance of the LLC. But like anything, it's much better to have a written operating agreement. So if you do have a written operating agreement, one of the things that is typically controlled by the agreement is how interest can be transferred, because individuals don't want to have a third party forced on them by a transfer from one person to another and have that third party be part of the LLC with them. So frequently what we see is that when the transfer occurs, and it could be, if a member decides to leave, if someone becomes a new investor, if an interest is sold, or if a member passes away, for example, typically what you'll see is an assignment will be prepared, and the assignment will the assignment will, I was trying to say to select the highlight, but the assignment will need to comply with the terms of the operating agreement to see who needs to consent to the assignment. So right there, this is very important. Sometimes only the consent of the manager is required. In certain situations, you might need the consent of the manager and a majority of the members. And in certain situations, you might need the consent of the manager and the unanimous consent of the members. So if you are doing planning for this, you want to make sure that those terms have been complied with, because as a general rule for the LLCs, if the corporate formalities are not respected, then the court is not going to respect the LLC as an entity, and the client's not going to get the protection that the client thought they were going to get from the entity. So on the page here that we have, that really is a key item that I think needs to be considered and addressed for clients and for practitioners. All right, and I'm having a technical difficulty here, so hold on one second. There we go. Another item that we strongly recommend as a checklist item, or a tip, or it could be a trap, is the preparation of annual minutes. With the annual minutes, it's similar to what you would expect for a corporation or for a company. The annual minutes, you would need to list what the general assets of the LLC are. It could state what the ownership of the LLC is. It should definitely state if there were any changes in the ownership of the LLC through the course of the year. In addition, you can state if there are any loans payable or loans payable to or due from the LLC. And if those loans were made during the year, or if any payments were made on them, or if there were any changes to the amounts that were owed. Those are all things to list in the minutes. Any other material structural changes, that would be good too. Again, because what you're trying to do is create a basis showing that the corporate formalities of the entity have been followed, that you handled the entity not just as a family entity, but you've handled it in a way that if you were dealing with a third party, that third party would expect you to handle it. And by that, I mean, especially what's important, and we'll talk about this in more detail, is if you make a distribution from the LLC, it needs to be pro-rated from the LLC to the members. So if the clients own 90% of the LLC directly, and they formed a gifting trust that owns 10% of the LLC, it's vitally important that when the asset distribution comes out, 90% of the value goes to the clients and 10% goes to the gifting trust. And the same with respect to if contributions are made to the LLC, 90% should be made by the client, 10% by the gifting trust. Now, in the event that a contribution can't be made pro rata, or a distribution can't be made pro rata, or it's not intended to be made pro rata, you can enter into what's called an adjustment agreement, which we'll talk about in a little bit as well. And what that does is documents the fact that the members recognize that there was a non-pro rata distribution made from the LLC, or contribution made to the LLC, that it was intentional, and then as a result, the ownership interests of the LLCs were going to be adjusted to take into account the change of ownership, which would reflect the non-pro rata contribution or distribution. All right. So we'll talk about that in a few more minutes. But again, one of the things that you need to look for when you are working with LLCs and representing them, preparation of annual minutes. It's important, and it will help to go ahead and make sure that the corporate formalities are being filed, or followed rather. One thing to think about as well when you're forming the LLC, another item on your checklist, is a choice of entity. By choice of entity, we mean how is the entity going to be taxed? And the LLCs have a great deal of flexibility, depending on the number of members and depending on what the client wants. The LLC could be treated as a disregarded entity, meaning it's ignored for income tax purposes essentially, and just picked up on the owner's personal income tax return. Now, to be a disregarded entity, it would have to be 100% owned by an individual or by another entity. There can't be two owners. In addition, the entity could be treated as a partnership, and again, it would be a partnership for tax purposes only. So when I say that we could form an LLC that's a partnership, I don't want you to think that we're forming a state law limited partnership. We would be forming a state law limited liability company, a state law LLC. But that LLC can elect to be taxed as a partnership, or it could be simply taxed as a partnership, depending on how many members the LLC has. So if it has multiple members, then the LLC would have the option of possibly being taxed as a partnership. Another option for multiple members or for a single member is that the entity could be taxed as an S corporation. So we would form an LLC, and again, we're not forming a corporation in the sense of an Inc. at a state law standpoint. We're forming an LLC at a state law standpoint and electing to have that LLC taxed as an S corporation for federal tax purposes. That's permissible. You need to make sure that you have the requirements for an S corporation satisfied in your documents, and we'll touch on that a little bit, but you want to make sure that you have restrictions in your documents preventing a disqualified shareholder from becoming a member. You want to make sure that it's limited who can own the shares so that you don't blow the S election, and that other activities are curtailed to prevent the S election from being blown as well, which you can put in your operating agreement. And if you'd like to see some of the provisions that we have for that, let me know and we'll be happy to send that to you. And in addition, the LLC can be taxed as a C corporation. We'll touch on that a little bit in a little bit more detail in a minute. So if you do have a single owner, the LLC can be disregarded. With a single member LLC, it doesn't have to file an 8832. It just automatically is a disregarded entity. All right, that's a default election. The other option would be for it to be treated as a corporation, either a C corporation or an S corporation. And depending on what the activity is, it would be reported on the personal 1040 on specific schedules. Now with a partnership, the partnership's the default status for an LLC if you have 2 or more members and it makes no election. So again, if it doesn't file as Form 8832 making an election, the entity will be treated as a partnership if it has 2 or more members. Then you're going to have the entity filing a partnership return, Form 1065. The LLC itself will not pay income tax on the income. The LLC would pass the income through to the partners because it's a partnership. And instead, the members of the LLC would be receiving K-1s from the LLC, reporting the income or deductions that the partnership earned. A C corporation would be another alternative, like we discussed. The one thing with a C corporation is that the C corporations are subject to double taxation, and that the C corporation itself is a taxable entity. The LLC itself would pay tax on the profits at the corporate rate, not the members. And then when the LLC makes a distribution by declaring a dividend, the dividend from the LLC, because it's a C Corp, would be taxable income to the shareholder of the C Corp, the member of the C Corp as well. Now, with the reduction in the corporate tax rates, this may be something that could be beneficial for certain clients. It's something that I encourage you to discuss with your CPA quickly. It might be a 5-minute conversation. It might be a much more in-depth conversation. Before the tax rates were changed at the corporate level, it generally didn't make sense to form a C corporation because of the double taxation. And so any LLCs that were formed as corporations or elected to be treated as corporations would elect to be treated as S corporations. And the difference between an S corporation and the C corporation is that the S corporation itself is ignored for income tax purposes as far as having to pay at the entity level. Instead, the S corporation functions like a partnership in that the income and deduction from the S corporation flow out to the shareholders and get reported on the shareholders' personal 1040. So if you are, again, looking at making an LLC an S corporation, there are various provisions that I have there that you want to make sure you consider and try and mitigate against having any of those provisions being violated by your members and the S corporation election being blown, such as having an ineligible shareholder. Another option that you might want to have in your operating agreement for an S corporation is if you have a provision with a buy-sell or anything determining the value of an interest being sold, you're going to want to make sure that that provision complies with the second class of stock rule. So at a minimum, the sale value should be the book value, so that the sale would require to be between the fair market value and the book value. So that in the unlikely event that an appraiser determined the fair market value was less than the book value, the sale still would occur for the book value to avoid the issue of having the second class of stock rules. All right, so one question that we get a lot, and it's something to make sure that you understand, is if I have a grantor trust, meaning that I create a trust for the benefit of my wife and my children, But for income tax purposes, I'm treated as owning the trust because I've retained certain powers, such as the ability to swap assets with the trust of equal value. I do not have control over the trust. So for estate tax purposes, the trust is outside of my estate. So what you'll see is this is a common situation. If we want to just go back to quickly the first couple slides. For instance, in this situation, the FLP that I have owned 1%, 96%, and 3%, with the 3% gifting trust irrevocable, or an even simpler situation, the FLP to the left of that. So I have it 97% owned by the clients as tenants by the entireties, and 3% owned by a gifting trust that's considered to be owned by the clients for income tax purposes. Now, in this situation, I have two different members. I have the clients as tenants by the entireties, and I have the client's gifting trust. But the gifting trust is a grantor trust, and because it's a grantor trust, it's disregarded for income tax purposes. So again, the entity itself, the LLC, now is going to be treated as a disregarded entity, meaning everything would be picked up on the appropriate schedule of the 1040 of the main member, the TBE member, and the owners of the trust for income tax purposes. And then the grantor trust can go ahead and file a informational 1041. It's basically a two-page 1041 with all zeros and a statement attached stating that the income associated with the trust is going to be picked up and reported on the grantor's personal income tax return and providing the information for that. So if that's something that you are interested in, we have a more detailed article and information on the filings and what needs to be reported. But one nice thing to know and to take away from this is that if you do create a structure with a gifting trust as the second member, you have not automatically created a partnership, meaning that you do not have an entity tax return that would need to be filed. It could still be treated as a disregarded entity. Now, from a protection standpoint, even if the entity is treated as a disregarded entity, we would recommend that the entity have annual books prepared, or even possibly a dummy tax return prepared that could be filed if the entity ever had to file a return. And it's not a concern from the fact that we're worried that the entity itself might have to file a return. The benefit of doing this is twofold, at least. One is that your CPA would have the opportunity to review what's going on with the company and spot any potential issues, such as pro rata distributions not being made or some other issue that needs to be addressed. And the second item, in addition to that, is besides having your CPA review the return, and even though it's not being filed, is it just lends the business credence, or lends to the idea of you treating this as a legitimate business and not just a family business. So even though an income tax return doesn't need to be filed, by having this dummy return prepared, it shows the financials, it shows all the information. It's information that can be shared with the members, and it helps again to just demonstrate that this entity is really an entity that exists. You treat it like it exists, and they treat it as if you were dealing with a third-party member. Because with a third-party member, you would want to know what was going on with the entity. I mean, you'd expect to have this information, even if a separate tax return wasn't necessary. Possible need for multiple LLCs, another item to think about and to discuss. Multiple LLCs are important for clients if they have activities such as rental properties. If a client has two rental properties under one LLC, we have rental property A, rental property B under LLC 1. If someone slips and falls on rental property A, then rental property B could potentially be exposed to a creditor claim because the person would be suing LLC 1. If instead the client had LLC 1 owning property A and created LLC 2 owning property B, then if someone fell on property A, they would sue LLC 1, but it would not subject the assets of LLC 2, property B, to a potential lawsuit. Now, this is important too if you have assets that could be exposed to liability and assets that aren't, okay? So some clients say, okay, I don't want to have separate LLCs for each of my pieces of real property, my rental property. That's fine. That's a client's decision. You want to make sure they make an informed decision, and that's acceptable. If that's what they want to do, that's what they decide to do. Now, that same client you might want to have a discussion with, because they might want to also put marketable securities in the same LLC as the real estate. So now they're really doubling down, because if you take the marketable securities and you put the marketable securities in a separate LLC, no one's going to slip and fall on your statement that you receive. Those assets are not going to be subject to a potential creditor claim of the LLC because of its activity. If you combine those assets and put them in the name of an LLC that owns rental property, again, if someone slips and falls on that property and insurance doesn't cover it, any asset of the LLC is exposed to the claim. So if the LLC has a marketable security account in addition to the real property, that marketable security account would be subject to the potential claim. So that's, again, other reasons why clients should consider having multiple LLCs. And like we talked about with the multiple LLCs, it does not mean that you're going to have multiple income tax returns. The entities can be structured so that they're disregarded for federal tax purposes, but still respected for state law for protection purposes. And that's in addition to the planning that you can obviously do with LLCs regarding sales of interest at a discounted rate for lack of control and lack of marketability. But that's something to discuss in another webinar. So again, just reasons why you should have different states or different LLCs. Another item too is that you might have property in a different state and there might be different reporting requirements, et cetera, et cetera. It's just something to consider, something to think about. Managing the LLC properly. Again, now this is kind of a checklist guide. It's things that we've talked about, but we need to make sure it's a separate legal entity and treat it that way. Don't use it as a personal checkbook, meaning the client shouldn't be just taking money out when the client needs to. It's better, even if there are pro rata distributions, that the pro rata distributions are not regular, so that, for instance, if the client needs $1,000 a month, I'd rather not see the LLC paying $1,000 a month to the client, even if it's pro rata to the ownership. It'd be better maybe that the client receives an amount every 6 months or every 10 months or just, differently. It doesn't have to be on a monthly basis. But the main thing is to make sure that everything is pro rata for distributions and contributions. Again, maintaining separate books, making the idea, and there's on the slide here, you'll see the please do at the bottom of the slide. You can gift up to $15,000 per year per person. And if you use discounted LLC interest, you're actually able to take a leverage on that and transform more wealth, in the sense that if you take a 30% discount and report it as a $15,000 gift, you're transferring approximately $21,000, $22,000 worth of assets. So again, it's something that we can discuss in more detail, but be aware that LLCs do make a great vehicle for annual gifting to a trust if the trust is structured correctly with crummy powers, allowing it to qualify for the annual exclusion. And it's something that clients should consider gifting to for children and grandchildren and more remote descendants or other beneficiaries. And what's nice is that after the 60-day withdrawal period expires, the assets are owned by the trustee of the trust, and the beneficiary himself or the beneficiary herself does not have control over those assets after the time period. So instead of gifting it outright to them or establishing a uniform gift to minors account or something like that where the asset will eventually be owned outright by the beneficiary, the asset can be gifted to a trust for the beneficiary's benefit. And then the level of control depends on the trust with respect to what the beneficiary will have over the assets that were being gifted. All right, don't contribute personal use items to the LLC. And if you are contributing other items, such as a vacation home, you're going to want to pay a portion of rent. Now, the payment of the rent would be ignored for income tax purposes at the federal level. But if the home, or if you form an LLC and 50% of the LLC is owned by a gifting trust that you're not the beneficiary of, maybe it's just for your children, then you would want to pay the gifting trust for half of any use of the family home. And again, it's not an event from an income tax standpoint at the federal level, but it helps to provide the additional creditor protection because the LLC is being respected and maintained correctly. And in addition, it would help to draw assets out of the taxpayers' estate who might be subject to estate tax. Again, having annual meetings, they're not necessarily required, but it's a good thing to have as far as it goes. Observing the corporate formalities, again, very important. Don't use it as a personal checkbook. Pro rata distributions. If there are non-pro rata distributions, you could do a promissory note, or we could adjust the ownership interest like we discussed. A couple of items to think about in your contract, or in your operating agreement as well. An executory versus a non-executory agreement. An executory agreement is an agreement where there are still actions that need to be undertaken by both sides that have been contemplated by the agreement. So both parties still need to execute a certain action or certain duties under the contract that they entered into. And a executory contract, it makes it harder in the event that a member is placed into bankruptcy, or in the event that there is a bankruptcy that occurs. It makes it harder for the trustee to just abandon the contract. So you want to have, and it's discussed in In Re Eman, we have the court case and decision here, but basically you want to put in provisions in your operating agreements, such as the affirmation of, such as having an obligation to make capital calls in the future, an obligation to be involved in the management duties, the fiduciary obligations. If you beef these up in your operating agreement, it will make it so it is more likely to be deemed an executory contract, and an executory contract is more likely to stand up in bankruptcy, an operating agreement that's drafted that way. So it's something to be aware of. Plenty of articles written about in Eman, including by our firm as well. If you want some more information on that, just let us know. And so these are some clauses that we have that we've added, considering, which we just went over. If you'd like to see some of the actual clauses, let me know, and we'll be happy to send that information to you. One other item to note, this is definitely a trap, is first come, first served. With respect to an operating agreement, it depends on if the operating agreement is controlled by Article 8 or if it's controlled by Article 9. So if it's Article 9, it's a first come, first served. Whoever places the judgment and secures the lien first gets the charging order. That's who is first in order. If you want to be under Article 8, which is what you typically would want to be if you're a lender to perfect the interest, what happens is the operating agreement says the LLC is electing for Article 8 to apply. Then the interest in the LLC can be represented by a certificate, and that certificate can be pledged. And if you're holding that certificate, you've perfected your interest. So in a situation where a family wants to sell an interest in an LLC to a gifting trust, or some other situation where there might be a creditor down the road, or a creditor situation arising for the gifting trust, and they need to make sure that the interest is perfected, that's one way to get it to do this without having to file a security or draft a security agreement and file a UCC1. And obviously, if you file a UCC1, you're going to be perfected under Article 9, first come, first served. But if they've already entered into this operating agreement, opting into Article 8, then you're going to have the protection without even having to file the UCC agreement or the security agreement. And that's discussed in the next couple of slides. Strangi and Powell, this is one of the last things I want to leave off with. When you're dealing with people who have possible estate tax exposure, many of those people have structured entities so that they have some of the voting control, or they've split the voting control. For instance, you would have an LLC owned 1% voting, 99% non-voting. Maybe the 99% non-voting interest is sold to a trust for descendants. The clients retain a 0.5% voting interest, and they gift away a 0.5 voting interest to the trust for descendants. So in that situation, that seems like it could be effective planning. Now, if we're in a situation where, though, that the operating agreement for the LLC allows the client to control certain things, then all of the value of the LLC can be pulled back into the client's estate under 2036. So what we've got here is 2036A1 and A2. Originally, the Strangi case had made it seem as though what was the issue for inclusion was if the grantor had the ability to determine if there would be distributions from the LLC. The Powell case has expanded that to make it clear that it's distributions from the LLC, the ability to control when the LLC will be dissolved, and the ability to control any amendments that could be made to the LLC. So what you need to do is create a special voting interest in the operating agreement, have that special voting interest owned by a third party that's independent, or a trust with a trustee who's independent, because in the Powell case, you need to make sure that the trustee of the trust or the person owning that interest is not someone who could act as an agent under the power of attorney of the client, because in the event the client gets disabled, then if that agent's acting as the power of attorney, that could cause the inclusion as well. So there's a lot of restrictions that have come into place as a result of Powell. If you'd like some more information on how to revise your operating agreement, we've provided some webinars on that, and we'd be happy to provide material on that as well. But for people that are subject to estate tax or potentially could be, they definitely should review their operating agreements for their entities to see if they're complying with Powell and Strangi to help avoid an unintended result whereby the assets get pulled back into their estate. Last two things, single member versus multiple member. Under Florida law, there's a big difference. I imagine most people are familiar with this, but because of the Olmstead case under Florida law, if I have two members in an LLC, the sole and exclusive remedy is a charging order. A single member LLC does not have a sole and exclusive remedy for a charging order. So the creditor can get access to a single member LLC's assets easier than they could to a multiple member LLC. Going back to what we talked about earlier, when I said having a gifting trust disregarded for income tax purposes as a member of the LLC, that the gifting trust could co-own it with the grantor of the trust, and the LLC would still be treated as disregarded. Again, that's for federal income tax purposes. So from a state law standpoint, I now have two members because the gifting trust is a member. And from a state law standpoint, with a second member, I would have the ability now to have the additional creditor protection as opposed to a single member. That's discussed here, as well as the charging order and the Olmstead case. Conflict of law issues and some other jurisdiction planning issues you might want to consider are just on the two slides we just went past. And then finally, I'm not going to go through this, but Alan has a checklist of 8 common planning LLC errors that we routinely see. Some of these I've already addressed, but I thought it was a good, concise little list of another checklist to provide you. So with that being said, let us know if you have any questions. We're happy to help with anything that you can think of that comes up from the material, or if you'd like some other material, let us know. And I appreciate everybody for the attention today and time spent. Any questions that you've emailed me, I'll do my best to get back to and responding. Sorry that I'm not able to do that in live time, but it's a restriction on the user here at my house. I won't blame it on the technology. So hope everyone enjoys the rest of the day, and thank you again.